Okay, hello and welcome to the panel on the protection of the individual under constitutional law and international humanitarian law. I invite our panelists to join me by opening their cameras. Professor Olga Poyadinok, did I pronounce your name correctly? Approximately. Okay. Okay, so we don't have all the panelists here yet, but we'll get started anyway. So again, hello, my name is Natalie Davidson, and I will be chairing this panel. We will be discussing three papers, which, as the title of the panel suggests, discuss the protection of the individual under both international law, but from the papers I can tell you already it's not just under IHL but also under international human rights law as well as constitutional law. And interestingly, I think all three papers can be seen to discuss a form of displacement. In the case of the third paper, it's physical displacement due to conflict. But the first two papers talk about what could be viewed as legal displacements, the imposition of nationality on individuals, so moving people into a new political community, so to speak. So as in the previous panel, each paper will have 20 minutes, after which we will have about 25 minutes for Q&A at the end. If you have any questions, please write them in the Q&A function at the bottom of your screen. Okay, so our first paper is titled Forced Nationality, and it was written by two co-authors who are here with us tonight, Dr. Tamar Megiddo, who is a senior lecturer in the Department of International Relations at Hebrew University, and Dr. Ronit Levin-Shnuel, who's a senior lecturer in the Faculty of Law at Tel Aviv University. And I'll introduce the next speakers right before their paper. So Tamar and Ronit, you can go ahead. You have 20 minutes.
Perfect. Thanks so much. We only prepared 15 because that was what we were told. So we'll see what we make of the time. So our title has actually changed from forced nationality to forced citizenship, and maybe we can talk more about why that was later. But let me start. Can you see my shared screen? Okay. But let me start with this. So nationality or citizenship is usually regarded as an overall good thing. This sentiment is perhaps best expressed in this phrase quoted from Hannah Arendt, although perhaps not always in the most accurate way. But the idea that Arendt wrote extensively about, that statelessness and the absence of a protective state exposed people to a world of horrors, is one of the main lessons that states took from World War II. And that is perhaps why, in the wake of the war, the Universal Declaration of Human Rights in 1948 included a right to nationality in Article 15 that has not, however, found its way into the 1966 covenants or other universally binding documents in such strong terms. So in this project, which I am doing together with Dr. Ronit Levin-Shnuel, we ask whether citizenship is indeed an unqualified moral good, and rather we explore the dark sides of citizenship. Now, citizenship may be conceptualized as both a sword and a shield. A shield is in one's relationship with any state, comes into expression when a person without a citizenship is in a state of bare life, as Agamben would say, has no protection. And citizenship provides that protection. The state of citizenship provides that protection. Citizenship also serves as a sword because sometimes individuals are targeted with adverse consequences on the basis of or because of their citizenship of a particular state. So not for anything they have done, but because of the passport or the citizenship that they hold. Now, we identify this duality as having to do with a tension between national or collective self-determination, which is how this term self-determination is usually deployed, and what we call individual self-determination. National or collective self-determination is expressed when we talk about a shield, so a state's discretion to determine who would be its nationals is expressive of its right to self-determination of the nation whose state that is, and it is to the members of its collective that it grants its protective shield. An individual's ability to determine their own identity and the community to which they would belong, however, may come into light when we discuss about the sort of citizenship, for it is sometimes the case that a person is subject to sanctions irrespective of their own willingness to tie their fate together with a nation whose citizenship they hold. That may come into conflict. Now, the project is currently planned to address 2 case studies with an additional third one considered. As you've seen, maybe in our rather rough first draft circulated, we have so far only delved into the first case study of enemy property. And the second, which was actually nevertheless the trigger for this project, we'll only outline today, and we would very much appreciate any feedback. And that has to do with forced nationalization of protected persons in the context of occupation law. A third that we are still only contemplating has to do with refoulement and refugee status. So starting with enemy property. Enemy property is a creature of the 20th century. In fact, in the turn of the century, it was rather firmly established that taking the property of enemy citizens only because they are citizens of an enemy state is prohibited. But World War I brought a shift in this normativity. In fact, it was already in 1914 that countries in Europe, as well as the United States, have legislated rules that allowed them to take hold of the property of enemy nationals and place it in the hands of a custodian that was to hold the seized property. But this was not the end of the process. Already as early as the Versailles Treaty ending World War II, the Allied powers assumed the authority to confiscate and not only seize the seized German property in order to use it to repay war debts and compensate for the damages caused to their own citizens as a result of the war. Now, this practice was repeated in World War II and well into the 20th century. In the United States, only a 1970s reform limited significantly the use of such confiscation of enemy property. Now, following 9/11 and the enactment of the Patriot Act in the United States, the authority to seize enemy property was once again brought into focus. However, this time it was only temporary seizure and not confiscation of enemy nationals' property that could be done, again, solely on the basis of there being an enemy national. And confiscation was only permitted in this new, more modern legislation in the context of armed hostilities against a person that is individually shown to be implicated in aggressive conduct against the United States. In other words, confiscation of property now required showing that the owner is implicated in wrongdoing. It is not based solely on their holding of the citizenship of an enemy state. Modern sanction regimes applicable to individuals, such as the freezing of assets of suspected terrorists or Russian oligarchs, follow a similar logic. A person's property is seized based on their conduct or their relation to the state's wrongdoing and not only based on their citizenship. What explains this shift? Our understanding, or what we suggest, is that this shift expresses a conceptual shift, and that is the rise of a human rights sensibility. Now, this engram that you see here is slightly twisted because there's much more mentions of human rights than of enemy property, but we wanted to show you the trajectory of these two ideas. One can no longer be slapped with sanctions today due only to their identity as citizen of country X, but has to be considered in their own individual merit. So this trajectory shows the decline of enemy property per se and the rise of human rights, which may explain this shift and the requirement to show that a person is individually implicated in wrongdoing. If we return to the idea of citizenship as a sword, then that sword's edge has been somewhat softened in the 2000s and since. State practice now prioritizes targeting a person not for their formal belonging to a certain political community, but for their own conduct. Our second topic is that of forced naturalization. Now, before we get to the occupation law example, we should look at the rule. And the rule in international law, already present in the 1930 Convention on Questions Relating to the Conflict of Nationality Laws, the rule is that states have the discretion to determine under their own law who are its nationals. Now, and the rule is that this law of each state shall be recognized by other states, but there is a qualification. It shall be recognized insofar as it is consistent with international law, that is, international conventions, international custom, and the principles of law generally recognized with regard to nationality. Now, what we ask ourselves is what happens when this naturalization, conferment of citizenship, is illegal? And here comes into focus the law of occupation, and particularly the rule forbidding the naturalization of protected persons, inhabitants of an occupied territory, that is famously written into Article 45 of the Hague Regulations. And I'll read it to you. It is forbidden to compel the inhabitants of an occupied territory to swear allegiance to the hostile power. Now, as you can see here, and in somewhat parallel provisions of the Geneva Conventions, the naturalization is not explicitly written into the article, but this is how it's been interpreted, as a rule that forbids the forced naturalization of the inhabitants of an occupied country. And the question we ask ourselves is, should third states recognize a forced citizenship, this compelled citizenship on the inhabitants of an occupied territory? Now, this question may sound like an easy question, but we in fact think that it isn't. So let me start with this. We said that the rule in terms of whether states should recognize citizenship is a rule of deference subject to international standards. That means, however, that when the international standards are not followed and citizenship is conferred not in consistence with international law, other states have discretion in terms of recognizing or not recognizing that citizenship. And that may pose a problem, because when states have discretion, there may be tensions between their own interests and the interests of the individuals concerned. So there could be several outcomes that could be considered in terms of recognizing illegally conferred citizenship. The first is that states will not recognize such citizenship. And the problem with this option is that it may lead to statelessness. There may be cases in which a person's only citizenship is the one that was imposed on them by an occupying power. And that is a problem. We know that international law, through various conventions, has striven since World War II to reduce statelessness and prevent it to the extent possible. Another outcome may be that states may be, from this concern concerning statelessness, that states may be obligated to naturalize these individuals themselves. But that is a conflict of interests, because states may prefer to recognize an illegally conferred citizenship and not be forced to provide their own citizenship. A third outcome is to indeed recognize that illegally bestowed citizenship. And the fourth outcome, which we are contemplating in this project, and this is our sort of inclination, is that this decision should be context dependent. And it should derive, and here we draw on the famous paragraph 125 from the Namibia advisory opinion. The decision should draw on the interests of the individuals. So perhaps the answer is that decision on recognizing or not recognizing an illegally given citizenship should be in each case and with a view towards the interest of the individuals concerned. And when their interests are advanced by such recognition, then perhaps that should be recognized, and vice versa. And the case with which we have in mind when we ask these questions, and which we will address in this project, is the case of the Jordanian nationalization of Palestinians. So very briefly, and I'll only outline the case, and I'll love to hear feedback in the Q&A section. In 1948, during the Israeli-Arab War, Jordan occupies the West Bank, including East Jerusalem. And in 1949, it nationalizes all inhabitants and confers Jordanian nationality on them. In the 1950s, it also annexes the West Bank. And then, as we all know, in 1967, Israel occupies these territories itself. And now the question that is asked is, should the Jordanian citizenship of these citizens be recognized? Now, this is no longer a valid legal question, because since 1988, Jordan no longer grants such citizenship. But it was at a very opportune and very important moment, a very lively question. And Israel has had its own interests in answering this question, not necessarily for the benefit of Palestinian inhabitants of the West Bank and East Jerusalem. And so our question is, how should this citizenship be regarded generally and particularly by Israel? And so perhaps by way of conclusion, let me just outline again the main dilemmas that we have been working on in this project. The first is this tension between the right to have rights and citizenship and the idea of statelessness. And alongside it, however, the concept of citizenship not only as a shield, but also as a sword. And finally, a question that we are interested in and will pursue in a bigger research project is this tension between an individual's ability to define themselves and choose their own community, political community with which they identify, and that of national self-determination or collective self-determination that may come in tension with the former. So thank you very much, and we look forward to the discussion.
Thank you very much. I see our co-panelists, Dr. Mitul Dutta and Shreyasi Bhattacharya, have joined us. So welcome. We're moving on now to our second paper. I remind people in the audience that if you have questions, including on the first paper, you should write them down in the Q&A function, and we will get to them at the end of the panel, in the last 25 minutes of the panel. So we are now moving on to our second paper titled Nationality and Citizenship Issues in the Context of Russia's War Against Ukraine by Professor Olga Poyedinok, who is an associate professor at the Taras Shevchenko National University of Kiev in the Institute of International Relations in the Department of International Law. So, Professor Poyedinok, you have 20 minutes. The floor is yours.
Thank you very much. I will share my presentation. Before I start, I would like to tell that at some point I may experience the same issues with electricity and or internet connection as Professor Natalia Hendel has experienced because of the Russian attacks against the civilian infrastructure. Of course, I will not apologize for that, because these are only Russian military to blame, but I hope that it won't be too annoying for you, and I will do my best in order to return to this Zoom session as soon as possible, if of course I disappear. But once again, fingers crossed. And please let me know if something goes wrong. And so let's start. So the first slide, you can see the title, Nationality and Citizenship Issues. and also within the context of Russia's war against Ukraine, and it is like the case study following the previous presentation, the previous general topic on the forced nationality, and of course at some point I will comment on the previous presentation as well, in particular about the Namibia case, and one more point regarding this presentation is this picture we can see on the first slide of this presentation, and I saw this picture and in the publication by Deutsche Welle, when the Ukrainian military forces deoccupied or liberated or regained control over the Ukrainian temporarily occupied territories in the Kharkiv region. And so, and they found the room, so-called basements, because we like in the Russian war against Ukraine, we have this technique used by the Russian occupation authorities aimed at the suppression of resistance by the civilian population. They call it the basement or podval, if in Russian. Basically, this is podval, or a basement, is a place where they put the Ukrainian civilians, and inside that building they torture people, they rape people, they kill people. And of course it is aimed at the intimidation of the civilian population and at breaking their ability to resist. So, and that picture was taken in one of those basements, and basically you can see this pile of invalidated Ukrainian passports. And you see the holes in those passports, and these round holes are made in the documents that are not valid anymore. And that is one of the things the Russian military and the Russian other personnel of the occupying authorities. That is one of the first things they do. They collect people and they collect the Ukrainian passports, and they invalidate both Ukrainian passports, Ukrainian identity, and also and afterwards they also cancel, kill those holders of those Ukrainian passports. And I hope that this picture gives you some idea about the overall context of the Russian passportization, so-called passportization or imposition of the Russian nationality to the population of the occupied territories of Ukraine. And of course, throughout my presentation, I will use both words, nationality and citizenship, nationality more within the context of public international law, and citizenship more within the context of domestic law, but of course to those people, to those our participants who belong to the so-called post-Soviet legal tradition, I must say, I must make a short disclaimer that in this presentation, nationality does not have anything to do with ethnicity, because here we speak about the Ukrainian nationality, the Ukrainian citizenship, being two sides of the same coin, meaning the legal link existing between an individual and the state. And of course, the general framework is Russia's war of aggression, and which I consider to be an attack at Ukrainians as a national group. National, I mean national in the sense of the judgment in the case of the prosecutor versus Jean-Paul Akayesu. And meaning the group defined by the common nationality. So Ukrainians are targeted as a political nation, regardless of their ethnic origin. Either these are ethnic Ukrainians, ethnic Russians, ethnic Belarusians, ethnic Greeks, ethnic Jews, ethnic Moldovans, no matter, and even Koreans or other ethnicities. So that is about the nationality as one of the elements of the political nation, of the state, of the statehood. So, and imposition of the Russian nationality on the population of the occupied territories here will be considered within the framework of IHL, but of course, as the International Law Commission in its report on the fragmentation of international law has mentioned, nothing in international law exists in a clinical vacuum, and everything is interconnected. And of course, IHL is not the only legal framework within which we can consider this forcible nationalization, but we will focus on IHL, and then we will consider the citizenship policy of Ukraine and the way it has transformed since the beginning of the Russia's war on Ukraine in 2014. So, as my predecessors have already mentioned, under Article 45 of the Hague Regulations, compelling the inhabitants of occupied territory to swear allegiance to the hostile power is prohibited, but there are also other provisions in the IHL dealing with the imposition of the nationality of the occupying power to the population of the occupied territories. First of all, such passportization, as we call it, the imposition of the Russian nationality, is incompatible with the Fourth Geneva Convention, because the Fourth Geneva Convention protects only those civilians who are not nationals of the occupying power. Violation, that is also violation of Article 47 of the Fourth Geneva Convention, deprivation of the population of the benefits protection under the convention. Then it is violation of Article 31, which prohibits the coercion against the protected persons, and also this imposition of the nationality entails compelling inhabitants of the occupying territory to serve in the forces of the hostile power, which is the grave breach of the Fourth Geneva Convention, and namely 40 and 47. So we see the framework under the IHL, and that is how Ukraine reacts on those acts committed by the Russian Federation. Basically, we have two groups of proposals. Some of them were more successful, some of them were not successful at all, but I can group all those draft laws statements and other forms of proposals regarding regarding amendment the Ukrainian legislation on nationality. So in two groups. The first group deals with facilitating the facilitation of acquisition of Ukraine's citizenship by foreign defenders of Ukraine. The second one is about additional requirements for candidates to become Ukrainian citizens. The third one deals with the loss of Ukraine's citizenship by those acting contrary to its national interests. And the last one, dual nationality issues, including those resulting from the Russian so-called passportization in Ukraine. So I will deal with each of those groups of proposals regarding amending of the Ukrainian legislation on citizenship. So first of all, Ukraine's passports for its foreign volunteer defenders. So as Ukrainian citizenship is now considered to be like an award, a prize for those who help Ukraine in its darkest hours. So there is a broad consensus among policymakers and the broader society, and there are solutions to prevent, and this Ukrainian passport is considered to be a solution for the prevention of persecution of Ukraine's foreign volunteer defenders in their countries of origin. And we also, we have and I have this in my paper, that we had 3 amendments already introduced into the Ukrainian legislation on citizenship, according to which more groups of foreigners who fight for Ukraine's independence and territorial integrity. More groups of those foreigners have facilitated procedure for getting the Ukrainian citizenship. And also there are other options available to ensure non-refoulement, but that is the topic for a different discussion. So, facilitation for foreigners who fight for Ukraine, it's okay, it is already in force, and maybe we will witness more groups covered by new amendments. Then, more stringent requirements for becoming Ukraine's citizens. Of course, now in public debate, we have the term citizen equalized with the term patriot. That is why we have numerous proposals dealing with more stringent requirements for becoming Ukraine's citizens. We already have the amendments that were adopted during the armed conflict. That is about the improving of the language skill check. And also we have one new novelty, the additional exam on Ukraine's history and constitution. Of course, that is in line with international law, including European Court of Human Rights case, namely Petropavlovskis versus Latvia. And also we have some unacceptable proposals. Of course, they were not adopted. There are some ideas to limit access to citizenship as a kind of collective responsibility, but our human rights defenders, they say no, we cannot introduce those amendments. So they have no chance, in my opinion, they have no chance of being adopted. Then we have proposals dealing with the loss of Ukraine's citizenship by those people acting contrary to Ukraine's national interests. None of those proposals has been adopted yet, because it is quite difficult, because Ukraine has many international obligations on the prevention and reduction of statelessness. And we have also the constitutional prohibition to deprive Ukraine's citizens of its nationality, and this also prevents Ukraine from, and we cannot change our constitution during the war until the martial law is lifted. And that here I also I mentioned the assessment of the French draft law on the protection of nation by the Venice Commission. It is an important precedent for Ukraine to have different sets of international obligations in the field of nationality and statelessness prevention. So, of course, that is very important for Ukraine, but not all the conclusions can be adopted directly in case of Ukraine. So, dual nationality issues in Ukraine, that is a very interesting question for the constitutional law of Ukraine. There are some ambiguities, and Ukraine's legislation needs some clarifications. And hopefully at some point the constitutional law of Ukraine will give the necessary explanations, because in late 2021, the group of Ukrainian members of parliament addressed the constitutional court of Ukraine with the question: what is meant under the single citizenship principle on which the Ukrainian legislation on citizenship is based? So that is for the Constitutional Court of Ukraine to give answers to those questions. If you are interested, I will be more than happy to answer your questions, but we need to move forward. And a very important slide on the dealing with the consequences of Russia's passportization. And passportization of the population of occupied territories breaches principles of general international law, because it is a part of the Russian aggression, the international humanitarian law, as we have seen, and also the international human rights law, because as the European Court of Human Rights mentioned in Genovese versus Malta case back in 2010, that nationality is a part of a social identity of the human being. That is why, for me, nationality is something more than just legal fact compared to birth, death, or marriage. It is more. That is why I cannot share the view regarding the possible application of those Namibian case rules to the issues of nationality, because it is not a fact, it is social identity. But we can discuss on that issue, and I will be happy to develop on that point. And the key approach in Ukraine is, of course, non-recognition, and not only of Ukraine, it is also the position shared by our so-called Western partners, by the EU in particular. More generally speaking, we have different draft laws, statements, other forms of proposals dealing with the with dual nationality or multiple nationality in general. But once again, considering the time limits, I will not go into details. So. And about conclusions and the way forward. So imposition of Russia's nationality on the population of the occupied territories must be consistently perceived and should be addressed adequately at the international and domestic constitutional level. And legally speaking, a citizen, a national, cannot automatically mean a patriot, and human rights must be respected. And also, Ukraine is under the huge scrutiny by international organizations, international human rights NGOs, whether Ukraine follows its international obligations in the field of IHL and also in the field of human rights. So in this situation, I can understand my Israeli colleagues very well. And any decisions must respect the law, including international legal obligations. And for Ukraine, the most important obligations are under the European Convention on Human Rights and Fundamental Freedoms, because we have this in our constitutional law, this convention and also the case law of the European Court of Human Rights have a huge importance. Once again, if you are interested in that field, I can comment on it as well. And asserting feasibility and practical consequences of any decision is a must, as usual, as everywhere. And ambiguities in the law must be fixed. And unfortunately, we have many ambiguities in our Ukrainian legislation on citizenship. I have that in my paper. If you are interested, you can see the details. And here is the final slide. Thank you very much for your attention, my contact details, and I look forward to your questions. Thank you.
Thank you very much. I already have many questions for both sets of presenters, but I'll be patient till the Q&A time. And we move on to our third paper titled Unpacking the Complexities of Internal Displacement and Armed Conflicts, the Indian Approach to Naxalite Insurgency. And joining us to present this paper are two co-authors, Ms. Shreyasi Bhattacharya, I hope I pronounced your name correctly, forgive me if I didn't, who is a PhD candidate at the West Bengal National University of Juridical Sciences, and also an assistant professor at the Symbiosis Law School in Pune. And her co-author is Dr. Mitul Datta, assistant professor at Symbiosis Law School at Pune in India. So you have 20 minutes. Thank you very much.
Good evening. Thank you very much, Dr. Natalie, for that introduction. And it was very great to hear the presentations of our former panelists, of our previous panelists. So our last panelist was giving the presentation on conflicts, and we'll just like to take it forward from there. So our paper is based on something which is specifically an Indian conflict, which is going on for a very long period of time. And what we are focusing over here are two aspects. One is the nature of the conflict, and the second is the issue of displacement which arises from the conflict. So we are still, this paper is still at we are still working on this paper, and there are a lot of complex issues and limitations that we have faced so far. So we'll try to be as concise as possible with our points. Forgive us if we lack in any areas, or if it goes on, if we meander too much into some areas. So we'll start with giving a background of the conflict which we are talking about, and we will be moving on from there on to the issue of displacement and why we are focusing on the nature of the conflict as a non-international armed conflict for invoking the Geneva Conventions to be applicable. So our main contention in this paper is that due to the large number of displacements which are still ongoing, which had happened because of this conflict, because of the Naxal insurgency, starting from 2000 onwards, there have been a lot of failure with regards to human rights of these people. And so as a result, and also even the domestic law, constitutional courts have also so far failed to provide them any kind of remedy when we talk about rights, from a rights perspective. So in this context, it is maybe useful for us to take a more international law approach and try to apply the protections which are there in the Geneva Conventions to the people who are being displaced, so that their basic rights could be protected, because the situation of these people are very very dire even now. So we'll start with an overview of the conflict. So this conflict, it started from 1960s. At least it has its ideological foundations were created in 1960s. There was a in the state of West Bengal, from where I am doing my PhD from actually currently. So in that state, there was a peasant uprising called the Naxalbari uprising. It basically happened when a peasant was beaten up by the landlord for not being able to pay their taxes and all, and they were deprived of their land. So this happened in 1960, around in 1967. So at that point of time, they the peasants around in the nearby villages, they gathered and a political group, the major political group which was in India at that time, the Communist Party of India, they picked up on that movement, and slowly its ideological basis were formed. Now, the main inspiration of this movement came from Mao's writings, Mao Zedong's writings. And so there this movement takes its name, Maoist Naxalite Insurgency. Okay. So this movement was led mostly by a splinter group of Communist Party. At that time, Communist Party was fragmented into several groups. A splinter group picked it up, and this movement then spread on from the villages to the cities, and it spread to other states as well. Now, in 1970s, when a new government came into power in that state, the government undertook major, conducted major security measures, and as a result of that, the movement was temporarily repressed. However, in 2000, the Communist Party of India, the splinter group which I was talking about earlier, along with the People's War Group, a guerrilla group, and one other party, they all merged together. This was a major coalition which happened in 2000, and they formed the Maoist Communist Party of India, Maoist. Excuse me, Maoist. So we call that CPIM. So that is the name which is given to this group now. So this is the formation of the organization, the militant organization, as we see. Now I would like to draw your attention to the map which we have given in our slide. This is the area of the movement. So the movement takes place from the area right above Bangladesh, that small red area highlighted. It started from there, then it spread to the other parts of India from 2000 onwards. And this period coincides with a lot of development projects being undertaken by the government at that same period of time, because the Indian economy was liberalized in 1990s. So parallelly, a lot of government projects were taking place, development projects were taking place. And what was happening was that most of these development projects were taking place in areas which were underdeveloped, which were rural, agricultural lands. So most of these lands, they are protected under the 5th schedule of the Constitution of India. And you need special permissions to undertake any kind of development projects over here. However, due to the rising number of projects at that point of time, there was a massive land alienation which occurred as a consequence of that. So, which is why we will be going on to, we have also talked about this in our paper, how displacement is not just a consequence of this conflict, it was in fact a cause of the conflict at the beginning. Now, talking a bit about this group, CPIM, so at its height from 2000 onwards to almost 2007-8, it was at a very, it had almost 20,000 regular cadres. It regularly recruited people from villages. It had a number of supply of arms, etc. And there were regular engagements between the government forces and CPIM forces and the Naxalite Maoist forces, I will call it, throughout this time. So, yeah, next slide. Just one more thing is that the states which had happened, just Dr. Mitul, can you please just switch to the previous slide once more? Yeah, thank you so much. My Zoom is not, I'm not able to share the slides on Zoom, so I asked my colleague to share it. So most of the displacement, it happened around these states: Madhya Pradesh, Andhra Pradesh, Chhattisgarh, Odisha, and parts of Maharashtra, the states which are highlighted in red, that area. So this understanding is very important, because the displacement has happened from one state to another. People have moved from one state to another, and as a result, they have suffered various human rights consequences. We will be discussing them later. Yes, next slide, please. Thank you so much. So, as I was telling about the causes of the movement, Maoist influence coupled with land displacement, these were the major causes. There are several scholarly studies, there is several literature available on this, on the governance aspect of the Naxalite Maoist insurgency. I'm not going into that because of the lack of time, but we will be happy to address that later on also. Due to which this movement took place in the beginning. And also, actually, in fact, in 2008, a planning commission was constituted by the government, which also pointed out the deficiencies which had taken place in the government policies for not properly resettling the tribal populations, for not rehabilitating them when the development projects were being undertaken, which had fueled the movement, which had basically changed the tribal sentiments towards, they made them sympathizers of the Naxalite Maoist insurgencies. And a lot of the people who were a part of this movement were also tribal people mostly. Yes, next slide. So now the Indian government, the hostilities broke out a lot between the Indian government, and it has even continued even till date. Very recently also, in this year only, there have been a number of casualties as a result of the hostilities taking place. But at that point of time, when this movement was at its peak, the government employed certain policies to placate the insurgents as well as the tribals. So one is, for the placation, they started taking development initiatives in these areas so that employment can be provided to the tribals. And another thing was that they started something called rehabilitation and surrender, in the sense that if tribals surrender or they would give them information, then the government would be giving them some kind of benefits, like some kind of employment, some kind of land, some benefits. So this was one aspect. The second one was security operations, and as part of their security operations, they created counter-insurgency groups. Now, these counter-insurgency groups, they are very important, because a number of displacement which happened was also because of these counter-insurgency groups. A lot of the counter-insurgency groups which were created in these states, they were made up of local tribal people. Particularly, there is one state called Chhattisgarh, where there was a major counter-insurgency movement which took place, which was funded by the government, and it employed tribal people. We'll be going into that also, discussing. So these were mostly paramilitary and police. They were formed to combat the Naxal the threat, and it came into such a huge issue that in 2006, the then government at that time, declared it as the biggest internal security issue that India has ever faced so far. So this was the gravity of the conflict. Now, coming to the now, like I said, that this conflict is going on even till date, but in recent years it has waned to a large extent. It is not in the same form as it is today. But one thing which happened out of the conflict is the large number of displacement. So next slide. Yes. So the large number of displacement which happened as a consequence. Now, the Geneva Academy, they estimate that around 70,000 people in 2015, around 70,000 people were displaced due to the armed conflict. However, the number is much more. In fact, there has been reports that in 2007-8 only, by 2007-8 only, 40,000 people had fled into neighboring lands. They were settling in other lands. Now, another issue happens is that data is very difficult to also collect for these people, because most of them, again, they are villagers. They don't lack proper identification. they are internally displaced. They're running from one state to another. So data collection has also been a task for these. There are no particular accurate, there are very few sources of proper data as to the exact number of displacement. So that is one of the problems we faced actually when we were coming across, when we were writing this paper. Now, so far, just to give you some picture about the gravity of the conflict, 8,000 casual fatalities, they were reported between 2004 and 2023. Almost 2,000 people had died. The number may be, in fact, maybe even more. So now the issue comes that how do we understand the displacement happening as a result of this? How do we classify the people who are being displaced? So owing to the large number of displacement, it's very important to classify them so that we can categorize them into a proper criteria and we can provide them the requisite protection there. So in this entire conflict, there are two facets of displacement. One is land-induced displacement, land development-induced displacement, and the other is conflict-induced displacement. Now, the problem becomes is that in India, it's first of all, India lacks a proper domestic legal regime for addressing displacement. There are some guarantees which are there. There are some laws, legal measures, legislative frameworks which have been undertaken for addressing, for providing compensation, rehabilitation to people who are displaced due to development projects. However, for conflict-induced displacement or disaster-induced displacement, as the popular criteria of displacement is internationally, there is very little benefits. That causes a lot of problems for these people. And in fact, when we were also doing our studies, we saw some reports where also local authorities had pointed out at their inadequacy in approaching the people, in rehabilitating the people, because they did not have any idea as to which law they should refer to. Should they refer to a land displacement related law, or should they refer to a disaster related law? How would we classify this as a disaster, or for at least giving them some kind of protection, or would we classify this as a land displacement? Because there is practically no legal measures for conflict-induced displacement, and that creates a plight of these displaced people. So first issue is that most of the displaced people, they were caught between the Maoists, the Maoist insurgents, and the security forces. So there were numerous reports, there have been numerous studies reports where it was shown that people feared going to the authorities for either being identified as a Maoist. If they would be identified as a Maoist, the security forces would be detaining them, or if they are going to the Maoist camps, then immediately they will be, if they are going to the government camps, then they will be targeted by the Maoists. So this plight was a huge thing. Insurgents would come, they would set a village ablaze, creating displacement, or on the other hand, the government forces would also come. They would pick up some people, detain them, torture them on the ground that they were Maoists. So this was a constant issue. This is still a constant issue which villagers face on a daily basis. So the displacement is happening on both the sides. One instance I would like to highlight particularly, because there is a lack of data on Maoist organization, Maoist Naxalites, it's a militant organization, so there's a very little lack of data, official proper data. But for the Indian government, there have been recorded instances where the counter-insurgency, the paramilitary outfits which they created, they would go to villages, they would threaten the villagers to go to the camps, to go to government camps, so that basically the villagers will not be able to join the insurgents. So one such group which was very infamous was the Salvajudum, and the Salvajudum was had been held responsible for creating a large number of creating a lot of fear among the local villagers, tribals, and also threatening them to leave their village, luring them into camps rather, and making them stay in camps, They would also go to the camps. There also they were committing a number of human rights abuses like rape, kidnapping, etc. And as a reaction to this, the Maoist insurgents, they would also go on to destroy civilian property, destroy village property, to threaten the villagers, kidnap children and make them soldiers. So basically creating child soldiers. So this is a plight which has been the main, the security factor. It's the main thing which has been facing, which the villagers have been facing for a very long period of time. To the fact that when they would go to the government camps, they would be immediately demarcated as Salwa Judum camps. This paramilitary, the camps were named after this, unofficially, they would be named after this paramilitary group. Now, when coming to the camps, there are a lot of local NGOs which have gone to the camps, and based on their research, they have found that there are massive issues like malnourishment, lack of livelihood opportunities. There would be scarce livelihood opportunities which would be given to villagers, but they would be very temporary work, like pond work, some road work, nothing compared to the agricultural cultivation that they were engaged in earlier on a generational, and the generational benefits that they would acquire from it. There would be disparate distribution of essential services. Some camps would have medical services, some would not have any medical services at all. Surveillance was massive on women. They would be, rape was a very common thing. It was a recorded thing there. So then, excuse me, village elders or other men would keep tabs on women on a regular basis as to where they're going. Their movements would be monitored. There would be no facilities for children or elderly, no education for children at all. So again, totally, the picture arises that there was these people, these displaced people, they suffered a lot due to this ongoing conflict. Now, the unfortunate part is that this conflict has been, these people have been suffering even today. So like in the next, thank you. Next slide, I have talked about the loss of land and livelihood. So one thing, for instance, which was recently reported was that in 2024, when these people were asking for land entitlements, they were unable to get remedies because they excuse me, there is no remedy which is there for conflict-induced displacement. There is, if they would be categorized under land development-induced displacement, that would be a different thing. But for conflict-induced displacement, they would not get any kind of remedy. So around 53,000 tribals were forced to flee.
Sorry to interrupt you. You have about 2 minutes.
Oh, I'm so sorry. Then I'll just quickly wrap up and I'll ask my colleague to talk about the nature of the non-international armed conflict. So
both of you for the whole paper, there are 2 minutes.
Oh, okay. So sorry. I think I took up too much time. So I'd like to request my colleague to just talk about the non-international armed conflict part and finish up.
Thank you very much, Sreshi. So as my colleague Sreshi has already discussed about the gravity of the Naxalite and the Maoist insurgency movements in India. Now, very quickly, due to the paucity of time, now if we talk about the laws which are applicable, so in this context, as Professor Sreshi has already mentioned, that there are constitutional guarantees which are which are extended to protect the rights of those who are displaced due to these the conflicts which are going on in the Red Corridor of India. And at the same time, if we look into the other laws which can be applicable in this context, is recognizing these displaced persons as internally displaced persons and extend the protections and the minimum guarantees. But unfortunately, as Sreshi has already mentioned, we do not have in India, we do not have any binding law, particularly which recognizes the conflict-induced displaced persons, groups of persons as IDPs, and we do not have a binding legal framework for the protection of the IDPs. Now, looking into the international legal framework, and if we talk about the conflict-induced displacement, we basically would like to draw your attention towards the Geneva Conventions, the Fourth Geneva Convention in particular, the second additional protocol and the first additional protocol, of course, and at the same time, the customary principles of international law. Now, as the previous speakers were also mentioning about the protections given under the international humanitarian law and the legal framework therein. So it basically applies to the international and the non-international armed conflict. Now, the question that arises in this context is that whether the insurgency movement in India, whether it can fall within the purview of the international humanitarian law framework. Can the Geneva Conventions and the additional protocols, can it be made applicable to such the nature of the conflict and understanding the intensity of the conflict? Can it be the protections provided within the framework of the Geneva Conventions, can it be extended to the civilians? So very quickly, if we look into the understanding of non-international armed conflict, which basically has been mentioned under the Common Article 3 of the Geneva Conventions, and at the same time, the second additional protocol to the Geneva Conventions. So if we look into the understanding of non-international armed conflict, basically it depends on the intensity of the conflict, the organization of the conflict, and at the same time, the nature of the conflict, which is systematic and widespread. So if we look into the jurisprudence which has also been developed over the years by different international criminal tribunals, and at the same time, owing to the nature of the armed conflicts and the understanding of armed conflicts, which has, in the post Second World War, from the post Second World War times, we have seen that the nature of conflict, it has drastically changed, and at the same time, most of the conflicts that is taking place today in different parts of the world, it is more of an internal nature. Now, as Sreshi has already mentioned, that Indian government has always classified the Maoist insurgency movement as a internal problem and a law and order issue. Right? So when we talk about the application of the IHL, it excludes the application of the Geneva Conventions to the internal disturbances and the law and order situations. However, there has been several decisions which has been given by the international criminal tribunals in different cases, like prosecutor versus Tadic, wherein the changing nature of armed conflict has been highlighted by the ICTY. Likewise, in prosecutor versus Alfred Muzema, the ICTR emphasized on the difference between non-international armed conflict and international armed conflict, and at the same time highlighted that the plight of the people and the atrocities or the violations of human rights which is conducted, which the civilians have to undergo, it doesn't really is not very different in an international armed conflict and in the internal armed conflict or a non-international armed conflict. And at the same time, in the case of prosecutor versus Boskowski, wherein the ICTY has highlighted on few parameters to classify, to understand the threshold that when can an internal conflict come within the purview of non-international armed conflict, and it has recognized few criteria, namely the intensity of the conflict, the territoriality of the conflict, the territorial occupation of the conflict, and at the same time the organization of the non-state entities with whom the state entities.
I'm really sorry. We have to wrap up, so there will be time for discussion. Could you wrap up in a minute?
Yes. Thank you very much. So, as my colleague has already mentioned, so the Naxalite insurgency movement in India, owing to its intensity and the widespread nature and the organizational structure that we see in these insurgent groups, they very well, we argue in our paper that they very well can be classified as a non-international armed conflict, and the extension of the protection which is given to the civilians, it should be made available to the civilians, right? And why is it important? One last thing that I would like to mention before concluding, that why are we advocating for application or for recognition of the Maoist insurgency movement as a non-international armed conflict? It is not only a matter of which makes a difference in the semantics and the nomenclature, but also the nature of the laws and the liability of the parties to the conflict. So if the situation is only considered as a law and order issue, in that case, the laws applicable are the domestic laws and the procedural and the substantive domestic laws, which are regulated or which are within the framework of the constitutional and the human rights framework. Having said that, when we classify or when we talk about the extension of the human rights law, there are multiple exceptions. There are exceptions like territorial sovereignty and territorial integrity of the state, sovereignty, and multiple other grounds on which the states can impose certain restrictions. However, that is not the case if we consider the application of the humanitarian law, which talks about a more universal, jurisdiction, and at the same time an extended liability. So there are multiple other things, but to conclude, there are, if we look into the Maoist and the Naxalite movement in India, the obligation of the state, can be classified. It can be termed as a twofold obligation, which is existing under the international human rights law and at the same time international humanitarian law. And the minimum standards and the guarantees which are provided under the Geneva Conventions for the victims of conflict, by classifying such, we advocate for classifying the Maoist insurgency movement as a non-international armed conflict, so that these minimum standards can be given and extended.
Thank
and the
you very
objective of
much.
IHL
We have to
Thank you so much.
cut you off. Thank you very much. I invite all the panelists to open their cameras. If members of the audience, if you have any questions, please write them in the Q&A. I see already one, but in the meantime, I'm going to ask each of the group of authors a question, which I will ask you to answer briefly, and then we will take the questions from the audience. So the first question is to Dr. Tamar Megiddo. I would like to invite you to respond to Professor Poyedinok's challenge. Okay, Professor Poyedinok disagreed with your approach of a context-dependent decision based on the special nature of citizenship. Right, Professor Poyedinok, you said it's not like recognizing a marriage or a birth certificate. This has a deeper meaning. So this really goes to the question of, to what extent is your project, Tamar, about, is it part of the question of what effect should we give to illegal actions under international law? Okay, does it follow that line of thinking, or is there something really citizenship granting and removal as a weapon of warfare? And so, if you agree with that, is it enough in your view to address this through violations of IHL? Or do we need to maybe develop a new concept? Maybe this is a new form of crime, because the IHL violations protect individuals, as the title of the panel, but perhaps what you are pointing to is a form of collective crime where there's an attempt to erase a nation through passportization, and the IHL violations don't capture that wrong. And while I'm here, I will give you a question from Benjamin Clark, who's asking you, have any Ukrainian children taken from occupied territory into Russia proper, sought and obtained reparations from any court for violations of IHL and or international human rights law? Okay, so those are two questions for you. And finally, to our last set of speakers, I understood you to be interested in the normative framework of IHL and also a bit international human rights law in order to provide a language and an appropriate category to make arguments on behalf of these these displaced people. But is it also, are you also seeking, in addition to the law, are you seeking the attention of international actors through this appeal to international law? And if you have any thoughts of this, how does looking at the conflict in the Ukraine and the conflict in Israel-Gaza, the way IHL and IHRL are poorly enforced, but also the way international actors are deeply involved and give attention, how does that influence your thinking about framing this particular conflict as a non-international armed conflict and bringing international law into the discourse? So Tamar, you can begin with a question to you.
Okay, thanks so much. So first of all, thank you, Olga, for pressing this issue. I think it's a very important point, and maybe I was not clear enough in our position. And I think you're correct, Natalie, to say that this is somewhere between these huge questions of whether to give effect to illegal actions in international law generally, where the default response is non-recognition, and the question which we are very busy with, and that is whether citizenship is indeed a unique case. And we tend to think that it is, and that is because it is exactly it is a legal expression of one's membership in a political community, and these are also the places where one's citizenship may become a problem for a certain person. And if you only think to the Not a Bomb case, which is, a paradigmatic case of where citizenship may actually be very harmful for you, then that's another indication. So to Olga, so we agree that non-recognition is the default response for an illegal action, and that forced naturalization is clearly an illegal action under the law of occupation. But we think, and we try to problematize this issue, that there are situations where this default rule produces harmful results. And I'll give just three examples. First is, which I've mentioned, but just for the sake of the answer, one is that sometimes in some situations, when you choose not to recognize an illegally forced citizenship, you leave a person stateless. And that also has very grave consequences. A second example is that sometimes citizenship serves to harm a person. And for instance, in the Jordanian nationality case, where Israel, to recognize or not recognize Jordanian nationality, a person could be could be led to dispossession. So this question is not without merit. It's not just the symbolic question, but the actual consequences of recognizing or not recognizing an illegally bestowed citizenship may leave a person dispossessed. And then the third is that a person may be deported based on a certain nationality. For instance, an enemy of a national of an enemy country may be deported in certain citizens that may risk them if it doesn't get up to the standard of non-refoulement. Then still a person could be very severely harmed only based on their citizenship. And so for these reasons, we are contemplating whether the default rule must not be at least complemented, and should not be the end of discussion, but at least complemented with a consideration of the interest of the person in question when forced citizenship or the lack of recognition of it may lead to adverse results.
Okay, thank you. Professor Poyedinok, would you like to answer the two questions I gave you?
Yes, sure. But first of all, thank you, Tamar, for having clarified. For me, it's the context that is really important. in our case, at least in the case of the Russia's war of aggression against Ukraine, everything is like black and white, and everything is obvious, and that is why there are not many points to contemplate on in this particular situation. So speaking about Natalie's question about the term. Actually, I like the term, which is like more or less widely spread, weaponization of nationality or weaponization of citizenship, which is not bad actually, because it can be applied within different contexts, and the Russia's war against Ukraine, we can analyze the pre-war period when the Russian Federation was distributing passports and made naturalization very easy in order to make many citizens of Ukraine Russian nationals at the same time, in order just to have more arguments in that field of humanitarian intervention. And speaking about the like reaction or counteracting these practices, and maybe it is a separate war crime or something. For me, it is more important not to invent something new, but to apply the existing international law. I mean IHL. I mean international human rights law. I mean general international law, and in my opinion, that is like, and I have that in my paper, that the Russia's war of aggression against Ukraine has some like genocidal elements, in my opinion, and I think that we can think this forced passportization as a part of this genocidal intent. And this makes, so this idea gathers the puzzle for me. And this leads me to the answer to the question in our Q&A box about the deportation of children. The deportation of children can also be considered together with this passportization as an element of this genocidal intent, because children, like the future of Ukrainian nation, the future of Ukrainian political nation, and they are taken to the Russian Federation in order to be raised by the Russian families, in order to be indoctrinated as Russians, and that is also one piece of the puzzle. And speaking about these very concrete questions, of course, the Ukrainian state and also the Ukrainian NGOs do their best in order to find those children, to bring them back to the territory of Ukraine controlled by the Ukrainian government, and of course, Ukraine tries to document as more cases of deportation as possible, and about the actions in international and domestic courts. So I will focus on this international plane. We have this element in the interstate case, Ukraine and the Netherlands versus the Russian Federation at the European Court of Human Rights. And the Grand Chamber hearing is scheduled for the 12th of June this year. And also we have the ICC arrest warrant issued regarding Vladimir Putin, the president of the Russian Federation, and Maria Lvova-Belova, the ombudsperson for children. And basically, these two arrest warrants, they deal in particular, they element of genocide, but it is very emblematic, I think, that these two arrest warrants were issued regarding those deportation of children. And speaking about the attention, yes, of international community to the conflict, of course, it can be this attention can be sometimes very unpleasant, but between 2014 and 2025 and 22, before the full-scale invasion started, actually we lacked this attention. When this international community turns the blind eye to this situation and telling you have a non-international armed conflict in Donetsk and Lugansk regions, while it is obvious for everybody that we had Crimea, which was occupied, that is international armed conflict, and those forces controlled by the Russian Federation, also that was international armed conflict since the very beginning. And now I say to my students just one small element, that this attention and this urge to comply with the obligations under international law is a compliment to the Ukrainian state, because they believe that Ukraine as a state is not a failed state, that it can and should deal in accordance with its international obligation.
Thank you very much. So the last questions for Ms. Bhattacharya and Dr. Dutta. So if you can answer briefly the question I asked you about your objective, does it also include, in addition to the law, international attention? And we have a question in the Q&A that's related. Are you looking to IHL because it offers a better protection framework than is offered under the Indian Constitution, which protects diverse human rights? So you don't have much time to answer that either, but if you could answer us briefly, thank you.
Thank you very much for the question. So talking about the international attention, the dilemma with respect to, when we talk about attraction of the international attention is the issue of sovereignty. And probably that is the reason why we see there is a difference, when we talk about the standard of protection extended under the international human rights and the humanitarian law framework and international criminal law framework, that the difference between NISC and non-international armed conflict and international armed conflict, it is existing actually. So the statist nature of international law, which focuses on the, which gives primary importance to the state sovereignty, right? But then, if we are talking about human rights and when we are talking about the rights of the people or of the victims of the conflict, I think, when we are talking about the displacement and when we are talking about loss of life and property and killing and forcing the individuals to forcefully migrate to a distant place, whether it is within the boundaries of the country or outside, whether it is due to an internal conflict or an international conflict, I think the violation or the atrocities which is faced by the plight of the people, it is very similar. Now, if we talk about the extension of the guarantees which is provided under the humanitarian law, it is more extensive and it is more, inclusive, and it makes a very much, the framework is much more stronger than the framework of protection which is available under the international human rights law and the constitutional law. So
Okay.
I can also see the question which is there in the Q&A box, which talks about the vast guarantee of rights which is there under the international Indian constitution, the human rights and the fundamental rights. But then, like I have said, and we have mentioned it in our paper as well, that these rights are not absolute and they are subjected to certain restrictions. And the state, can extend certain limitations to such rights. So if we classify the situation as a non-international armed conflict, the accountability to extend the protection to the civilians and to the victims of the conflict, it becomes more binding in nature, number one. And at the same time, we also have a law in India, in addition to the constitution, which talks about the Geneva, which is known as the Geneva Convention Act. It talks about the enforcement of the the protections. But then the law, the statute has it, it has its own limitations.
Mhm.
So therefore, we argue for, an increased accountability, not international attention immediately, but then to address the issues which are faced by the civilians, in their homeland.
Okay.
So yeah.
So thank you very much. You all managed to give detailed answers on time, so we have to wrap up. Thank you very much for this fascinating panel. I've learned a lot. So I'll remind everyone, tomorrow the conference reconvenes at 3:45 local time, so Israel time, for the second day of sessions. Wishing everyone well and a quiet, peaceful evening wherever you are. Goodbye. See you tomorrow.